constitutionally protected if accompanied by a parent, but not otherwise, suggests that we're talking about material that would be comparable to R-rated movies, where parents are able to bring their children, not to X-rated movies in which the state does not allow, in which the child may not go even if accompanied by the parent. If we're talking about the equivalent of R-rated video games here, that is not the kind of extreme violence that my friend likes to talk about.
What if the state said, we're going to ban these video games because it offends our community norms? Would that violate the First Amendment? How close do we have to get to the obscenity? Is there a First Amendment principle to distinguish the obscenity cases? Or is it just a historical accident?
Well, I do think that the history, it's not accident. History isn't accident. History is part of what our constitutional system is based upon. And when our framers protected the freedom of speech, they knew what they were talking about. Obscenity is a restriction of the application of the principle of obscenity has been with us from the beginning.
But let's assume in the 1970s when these obscenity cases were coming down that you had this graphic video games, so this technology was available. Would there be a First Amendment principle reason to distinguish them or not?
Well, I think there are a number of practical reasons why extending this to violence is a much larger and more troublesome proposition than to obscenity. If you were to turn on your television set on Saturday morning and watch children's programming, you will not see anything close to obscenity, not even close, not even suggestive. It's not part of the culture of present day. How about violence? Right? How about Wile E. Coyote? How about Bugs Bunny? Right? And the vagueness involved in this statute is at a level that this court ought to be extremely concerned about. For example, let me just give two examples of the vagueness of this statute. It applies, first of all, to video games that depict the killing of an image of a human being. Well, ordinarily we might know what that is, but in the context of comic book-like video games, what is the image of a human being? Does it include zombies? Does it include aliens? Does it include shapeshifters where people change from being a human being into being something else the next one? And how about killing? What does killing mean when in one frame you shoot the thing and it falls down, and in the next frame it springs back up to life?
What if it was a real human being? What if the video game, because it's sort of one-upmanship with kids' games, what if the new generation of games, they show real humans being killed or chopped?
Well,
That'd be okay?
It would have. Of course not, but not because of the communicative impact. It would be, then it would become regulable because we cannot create a market for something that involves the performance of a violent crime. But my point here is that's not the statute we have in front of us. We have a serious vagueness problem with this statute. I'm not saying that the state could never possibly write a statute that would satisfy vagueness, but the one that they wrote does not.
Counsel, is it because of the statute written in the words that this court has actually used?
Actually not. First of all, the words I've just been talking about are unique to this statute. That Ginsburg does not talk about an image of a human being. It has no reference, because it wouldn't. It has no, it has to do with a historic and well-understood category.
The statute doesn't talk about the video games have to be lacking serious artistic, cultural, etc. merit taken as a whole. Isn't it, doesn't Wile E. Coyote stand
It doesn't. And again, the statute upheld in Ginsburg referred to materials that were utterly lacking in artistic, scientific, etc. Benefit. This statute is way less protective than that. It requires, its language is that the game lacks serious literary, artistic, political, or scientific value. And just last year in United States versus Stevens, this court emphasized that language, serious value, needs to be taken, in this court's words, seriously. It means something. It means something quite different than utterly.
And I want to make sure I'm understanding you fully, Mr. McConnell. You're saying that if instead of saying serious literary or artistic value, if the statute was written to say utterly lacking in artistic and literary value, it would somehow be constitutional?
Justice Skupik, in the list of the multitudes of constitutional flaws in this statute, if it said utterly lacking, there would be one fewer to check off. And I would also, in thinking about, talking about Ginsburg, I here remind the court that Ginsburg did involve one of these traditional categories in which the speech, the underlying category of obscenity, is one that can be made illegal even as to adults. And so all that Ginsburg holds is that the state may, under some circumstances, alter the definition so that it's obscene as to whom. Well, obscene as to a minor might be slightly different than obscene as to an adult. Here we're talking about a category of speech which is not prohibitable as to adults. So it is not merely a matter of adjusting the definition of what is to be prohibited. It is creating a whole new category of prohibition.
Some of these video games made a mistake and had a few sex scenes in them. You agree that the state could regulate those?
And if it meets the standards of Ginsburg, the state could regulate them, yes.
But chopping somebody up, stabbing them, even a very realistic, looks like video taken, the most raw violence, you could not touch that. The state should not regulate. That is right. But let me just say what I think is really going on here is that I believe that this court accepted the pre-existing exceptions to free speech principles, not because they necessarily made logical sense under some sort of cost-benefit analysis, but because of history and tradition. And I think that in Stevens, I don't think that if Ginsburg were decided on the basis of a cost-benefit analysis, it would come out the same way. So what this court has said is we are not going to backtrack on those historic exceptions, but nor are we going to add them. That is the holding of the Stevens case last year, and there's a good reason for that, because as we open the door to more and more categories of exceptions from freedom of speech, that each of these exceptions has a grow like Topsy possibility to them.
So the state now controls the messages to which children are exposed fairly extensively, including expression of messages to children that are perfectly permissible, could not be prohibited as between adults. So there are state laws that require children to go to public school unless parents opt them out, and states heavily regulate what is taught in the schools, content-based restrictions. You may not teach racism and sexism. Some states you have to teach sex equality. Race equality, you must teach abstinence only. You can't teach sex is good, just be careful. In the family law context, courts routinely tell one order parents not to say anything that might imply disparagement to the other parents. Are these all unconstitutional controls of what messages children are receiving?
Well, Justice Dwyer, I don't want to give one answer for a whole series of questions that involve quite different constitutional doctrines. But let's begin with school. Yes, the government has a right to require that all children be educated. No, it does not have the right, as we know from Pierce against Society of Sisters, to say that all children have to be educated in government schools. People, institutions, churches, families have a right to create alternative schools, and they don't have to teach the messages that you're talking about. And so government is able to convey its messages, it's part of its right of speaking. Parents are able to create alternatives if they wish. It is not a regime, in fact.
Well, what's the difference with this? I mean, the parents have the right to give these games to minors, just as they have the right to pull them out of public school. Isn't the statute consistent with that structure you described?
I don't think so, Your Honor, because in this case, essentially what you're doing is you're telling an industry that it may not sell, it may not distribute materials that violate certain very ill-defined norms, right? It's not, this statute has nothing to do with parents. Parents were not mentioned below. The statute states its purpose. It doesn't mention assisting parents.
The idea that parents are being facilitated was not argued in the lower
Counselor,
courts.
what the statute says is that the industry cannot sell these particular games that fit this definition to minors. The age cutoff is 18, is it not?
That's right.
Okay. Is there no age at which the state could regulate and prohibit the sale of these games?
Is there no age at which a properly drafted, properly limited statute with proper evidence might be sustained? You know, I'm not going to say that there's not. What I'm saying is that this statute, as badly written as it is, as overbroad and vague as it is, as poorly supported as it is, where the evidence presented does not focus in on the regulatory issue, and I'd be happy to talk about that, cannot be sustained.
Okay, so the First Amendment would not protect, or are you then saying that such a statute as you've just described might survive strict scrutiny?
I'm saying that I need to see the statute, and I need to see the studies, and that it should be properly
There is an
litigated.
age, there is definitely an age then at which the state could act to protect minors from this kind of material through the criminal law.
When you say this kind of material, a great deal of the difficulties, we do not know what this kind of material is, because we have a statute that is so poorly drafted that we don't know what it means.
A statute drafted with sufficient clarity that it reached the kind of material that Mr. Cruz has described.
It is quite possible that
Extreme
I can easily imagine that such a statute might satisfy strict scrutiny.
Let me ask you this. Your industry has its own voluntary standards. Is that right?
Yes.
And how does it decide when a particular game is inappropriate for 10-year-olds, or when a particular game is inappropriate for 18-year-olds? What standard does it apply?
Justice Cooper, I don't believe that the record contains the criteria applied by the Voluntary Industry Board. What we do know is that FTC studies of this have found
Do you
most
represent this industry?
I do.
I'm asking you for the answer.
Yes, I do.
I understand.
I still do not know information. And if I did, I would be under some kind of moral and ethical obligation not to spill it out. What we do know is that there's been no objection made to the quality or type of performance that the industry has. The FTC, the surveys indicate that parents are quite satisfied, they understand, they are aware, vast majority of parents aware of the standards, and that the standards are obeyed and respected in most of the retail stores of America. So we have a problem that doesn't exist.
Mr. McConnell, why does the industry voluntarily prohibit its members from selling certain violent games to minors?
I assume because of consumer demand.
Not because that consumer demand reflects a concern that the minors would be harmed by that material?
The record does not reflect the reasons behind this.
You just
But
pick a reason randomly.
But there are, for private organizations to engage in self-regulation is one thing. Even with respect to speech, there's a great deal of speech that we have a right to do, even though it inflicts social harm. And in this case, when the industry has voluntarily engaged in self-regulation, there doesn't seem to be any pressing need for the government to step in.
Well, I wonder if that is true. The FTC study that you have referenced frequently evidently indicates that a substantial percentage of minors are able, without the presence of a parent, to buy these kinds of games. And is the state stepping in simply to put some enforcement teeth into the very lines that the industry itself is drawing?
Again, under the First Amendment, there is all the difference in the world between private industry, private people choosing to restrain their speech and having the government coming in and restraining them for them. So it doesn't seem to me